That's fine. Let me just double check my mouse here. Page down. Okay.
All right, very good.
You see the disclaimer?
Yes, sir.
Okay.
Good to go. Okay, everyone, thanks for being with us today, Friday. Remember, poll questions going to pop up. Just glance up and check those every now and then. Q&As, chats, everything's the same. So we'll go ahead and get started. Thank you for your patience, and we will welcome back Mr. Dermot O'Neill.
Yeah, thanks for your patience. I tried a new system here to get my picture so you can see what I look like, and again, it's we had some problems with that. We'll still get our 100 minutes in, no problem with that. The bankruptcy, insolvency, and reorganization, learning objectives. Understand the role of financial forensics in bankruptcy. Actually, it's a broader role in that financial forensics is rather a nebulous definition. But what we have in bankruptcy is what we call financial advisors. Financial advisors is typically an individual or a team, and that individual or a team will handle pretty much the entire bankruptcy, which could involve certainly investigation, business valuation, consulting with your clients, etc. So in bankruptcy, the individuals who are involved with the finances and excuse me, advising committees are basically the financial advisors, of which a forensic accountant or forensic investigator may be part of. We're going to hopefully get so you can see some underlying causes for insolvency. Of course, insolvency can lead to bankruptcy. Discuss elements of turnaround management. Turnaround management is a process which generally starts prior to bankruptcy. When a company is starting to have problems, they may call in a turnaround management company to assist them in changing their organization, or they in fact may assist them in filing for bankruptcy. I have a client right now who is in, I think it's Idaho, and they resisted my suggestion that they go see a turnaround management company. I was doing some business valuation work for them, and they were in bad shape. So the turnaround management people will basically assist a company that's in trouble. One of the steps might be bankruptcy. Hopefully, we'll get you familiar with some of the legal issues surrounding bankruptcy and differentiate between the types of bankruptcy and review considerations for reorganization and due diligence. In other words, what is a reorganization, what's due diligence, and so forth. Now, the role of the financial advisor, rather than financial forensic, is fact-finding and investigations for whatever party you happen to be engaged by. It could be the debtor, could be a trustee, could be a committee, could be any number of people we'll get into a little bit later. Now, part of the bankruptcy process is developing a plan of reorganization. And one of the roles of the individual who's the financial advisor will be evaluating whether or not that plan is feasible. And there's a lot of back and forth typically between the committees and so forth relative to the feasibility of a plan. We'll talk about the plan of reorganization a little bit later, but basically from a procedural standpoint, if the debtor the company filing bankruptcy, they have the first opportunity to create a plan of reorganization. If their plan of reorganization cannot be agreed to by most of the parties, then the other parties have an opportunity to create their own plan of reorganization and submit it to the various parties for approval. So it's not a fixed, it's a living document, if you will, this plan of reorganization. Then we have the involvement of the financial advisor in the confirmation proceedings. There's hearings, The financial advisor is with their particular client or their client's attorney to assist during the hearings and so forth. And finally, there's assistance with recovery actions. Recovery actions basically are situations where the debtor will attempt to claw back some disbursements that have been made previously. And they take all kinds of different shapes. I was involved with one, for example, which was an S corporation, and the S corporation paid out about $1 million to the shareholders so they could pay their income tax obligations. And shortly after that, they filed for bankruptcy. And one of the issues in the bankruptcy, there was a filing of a recovery action to get back the tax disbursements that had been paid to the shareholders by the S corporation. Fortunately, we won that one on behalf of the shareholders. Some more roles: assisting the debtor in analyzing operational problems. This is something that's done frequently in bankruptcy situations and bankruptcy reorganizations. You know, what was really the operational problem? What caused the bankruptcy? Can it be fixed, etc. Assuming the company is going to get out of bankruptcy, which we are typically in these situations, all the parties will be working on developing turnaround strategies. There are special financial statements that need to be prepared, usually monthlies, MORs, monthly operating reports that are filed with the court on a monthly basis. Evaluating the organization, evaluating management, all that's part of designing the turnaround strategies. And assisting with the preparation of court required schedules and forms, and finally aid in the development of a business plan, because it's more than just a plan of reorganization. Once the company is reorganized, what does the business look like after the reorganization? Now, I'm assuming that the participants are mostly or mainly CPA firms or CPAs. It's not uncommon to have a CPA firm that does nothing but preparing the monthly operating reports and preparing the court-required schedules and forms that we'll see in detail a little bit later. We're not going to spend a lot of time on it. It's just a listing of the forms. But there's an awful lot of forms that need to be prepared by the debtor during the bankruptcy process. And some firms have made careers, for lack of a better word, out of just preparing these forms. In addition, in preparing the forms, that firm might also be engaged to prepare the tax returns, payroll tax returns, etc., for the debtor if the accounting firm for the debtor doesn't want to do that work. So there's a lot of work to be done in the in the bankruptcy area. Compensation is a key term when you're doing this work. You know the company's in trouble, so you need to be aware of your compensation issues. Now, in a bankruptcy proceedings, there can be a couple of, and here we have some examples. There can be a trustee. There may or may not be a trustee, but there can be a trustee. If there's a debtor in possession, that simply means that the debtor is allowed by the court to run the company while it's in bankruptcy. If there is a debtor in possession, it would be unusual to have a trustee. It's usually one or the other, but they both serve the same function of operating the company while it's in reorganization. Could be a creditors committee. You could be retained by the creditors committee. Typically, these are the parties in a large percentage of the bankruptcies, so either a trustee or a debtor in possession, and a creditors committee. In bigger bankruptcies, there can be different committees that have the same weight and the same bearing as the creditors committee. For example, there can be a secured creditors committee. There can be an unsecured creditors committee. There can be an equity holders committee and so forth. All these are parties that have an interest in the goings on of the company and the bankruptcy. So you as a financial advisor can be retained by any of those committees. And the trustee or debtor in possession, as the case may be. The bankruptcy court has an independent duty to review all fee requests. Now, let me take a step backwards. As far as fee is concerned, there are procedures that you need to go through to make sure that you are appointed by the court. Unless you're properly appointed by the court, you can send bills till the cows come home, but you're not going to get paid because you haven't been court appointed. So if somebody comes to you and say, oh, I have a bankruptcy engagement, I want you to fill in these forms, the monthly operating reports and so forth, and you say, oh, that's great. You send them an engagement letter, etc. You may not get paid because any work for a debtor in possession or during the bankruptcy process needs to be approved by the court. If it's not approved by the court, there's no shot at getting paid. You might get paid as a matter of luck, but technically you don't have to get paid if you haven't been appropriately approved by the court or appropriately engaged by the court. Now, since the bankruptcy court is engaging you or giving their blessing to you being engaged, they also have a duty to review all fee requests. In larger cases, the court might engage what we call a fee auditor, which is a firm that goes in and audits the billings of all the financial consultants or all the financial advisors that are involved with the bankruptcy. We always, when I was doing this work, I used to joke that we always wanted to have big four firms who were advisors to some of the other committees because their rates were $600 and $700 an hour, where our rates were $400 and $500 an hour. And so the fee auditor would say, oh, it's only $400 or $500 an hour. They wouldn't spend a lot of time. They'd spend all their time on this $600 and $700 and $800 an hour work, and in some cases, $1,000 an hour work. So that's the one consideration, is the rate. The other consideration that the fee auditor looks at is the work that was done, the time that was required, and the level of staff that was assigned to do it. So if you have let's say, doing reviewing a cash disbursements journal, for example, to keep it real simple, and somebody is doing that at a rate of $450 an hour, the fee auditor is going to squeal and not be particularly interested in approving that particular bill for payment. So, and the fee auditor is generally engaged by the bankruptcy court itself because the bankruptcy court has the ultimate obligation to review all the fee requests. Which is the next bullet point. It's the ultimate responsibility of the court to monitor the requests for fees and to be paid from the estate. That's the other item that's and we'll see about this a little bit later, paid from the estate. It's usually the bankruptcy estate or the debtor in possession, as the case may be, to pay the fees for all the consultants. And it can be pretty hefty. I was involved as a financial advisor to a committee in the case of a small publicly traded company. Stock was sold on the market for about $5 or $6 a share. The gross revenue was about $5.5 billion a year. And that company was paying out about $70 million a year in fees to all the various consultants. Those were fees after those fees were approved by the bankruptcy court and after the fee auditor had reviewed them. We kind of alluded to this a little bit earlier. A reasonable compensation standard must be applied. Again, it's a reasonable compensation rate most of the time for the individual that's assigned to the project. And as we indicated earlier, an appropriate individual must be assigned to that particular function. There has to be a reasonable compensation, a reasonable salary, a person at a reasonable level to be assigned to the work that's being done. It's also possible that the court may award compensation that is less than the amount requested. Not uncommon when you have a fee order. The fee order may say that this bill was too large because the staff assigned was not appropriate at the appropriate level and so forth. So it is quite possible, and does happen occasionally, where the fee is not approved by the court. Now let's talk about the roles and who the debtor in possession, or we call them the DIP, refers to the management of Chapter 11 debtor that continues to control and operate the business. So the debtor in possession, the DIP, is the company that's in bankruptcy, and they are actually running the company and managing the company during the bankruptcy process. If there was no debtor in possession for whatever reason, then more likely than not, there would be a trustee appointed who would be running the company or running the bankrupt estate during the bankruptcy process. One of the things that's really, really critical, and we get into a lot of arguments about during the bankruptcy process, excuse me, is that management has a fiduciary responsibility that it must exercise with utmost care, placing the creditor's interest above the best interest of the shareholders. This is a very, very important concept, is that the management, be it a trustee or a debtor in possession, has a fiduciary responsibility for the best interest of the creditors as opposed to the best interest of the shareholders. That can also get into litigation. There's one public company, for example, I was just mentioned. The judge basically said that the shareholders had no value. These were the shareholders of the publicly traded company, that the company had no value because of the liabilities. It was an asbestos case. So there was hundreds of millions of dollars of liability. The shareholders sued. The shareholders sued in bankruptcy. They said, no, Your Honor, you're wrong. There is value. So we went through a whole process of the shareholders got, I believe it was E&Y at the time, to do a business valuation of the company. Our committee did evaluation, the trustees committee did evaluation, unsecured creditors committee did evaluation, and it came out something like the shareholders, E&Y, said, okay, fine, the value of the company was $8 billion. Our estimates were around the $4 to $5 billion. And 2 days before the trial was to start, the shareholders settled and said, okay, fine, we'll give up our shares, but we want warrants and we want rights to purchase the stock in the future at a specific price. So these are the kinds of litigation situations that you can potentially get involved with in bankruptcy, and where the financial advisors are heavily involved. It was real interesting in that case because the trial was in Oakland, California, and of course we're all over the country, so people traveled to Oakland and they settled actually in Oakland. So the judge took the opportunity, since they had all the parties there, to have an informal discussion with all the parties relative to the evaluation and the different roles that the judge thought the different parties in the excuse me, bankruptcy, not valuation, different parties in the bankruptcy had, and encouraged, I guess is a nice way to put it, the parties to attempt to settle any differences that they had. So management has a fiduciary responsibility that's absolutely critical. Now, each district has what we call a United States trustee, and the United States trustee appoints a committee of unsecured creditors soon after the court enters an order for relief. Now, what this means quite simply is that the United States trustee is actually part of the Justice Department, and the United States trustee overlooks or oversees the bankruptcy process. Oversees the bankruptcy process, let's say, period. If there is no debtor in possession, the United States trustee will appoint a trustee to manage the company during the bankruptcy process. They're like an overseer, if you will. The court-appointed trustee, if the United States trustee, appoints a trustee, the court will basically approve that trustee, can appoint other credit and equity security holder committees. So the trustee, if one is appointed instead of a debtor in possession, basically can appoint committees as they see fit. Of course, the parties, the equity holders or the secured creditors or something, can request that they have their own committees, and all that goes through and is approved by the trustee. These committees that are formed by the trustee generally consist of the 7 largest parties in each class who agree to serve. And by each class, that means which committee: securities committee, unsecured creditors committee, secured creditors committee, et cetera, whatever it happens to be. Again, the committee members must act in a fiduciary capacity to benefit all members in their class and not for their individual interests. It's quite common, particularly since you saw up above, that these committees are composed of the 7 largest parties. It's not unusual for the 7 largest parties to be concerned specifically with their own interests. And one of the requirements of the committee members is that they act in a fiduciary capacity to benefit all the members of their class and not their individual interests. Now, you can imagine where you have multiple committees composed of 7 members each. There gets to be some rather active discussions about what's better for the, we have potential contrary class interests, where you have the secured creditors, for example, looking out for their interests, and you have the unsecured creditors looking out for their interests. So when there's a proposal in the plan of reorganization, they may take opposite positions to a particular proposal. And that's where you get into a lot of the conflict and a lot of the discussions involving these particular committees. Can get rather active and rather heated at times. When a committee is formed, the committees can apply to the court for authority to engage professionals to assist them. This is the process that we talked about earlier, where you are approved by the court. In other words, you need to be approved by the court. The official committee has to say, we want Dermot O'Neill as our financial advisor. I have to submit certain documentation to the court, and the court has to approve it. If I don't do that, I'm not getting paid. So that's an issue that we want to keep in the back of our mind. Wendy, just as a point, I don't have the question box up, so if there's any questions that come in or anything like that, feel free to interrupt me when you think it's appropriate.
Absolutely, will do.
Okay, thanks. Okay, so that's the situation with the various committees, security holders, creditors committees, and so forth. In asbestos litigation, there are tons of committees that get involved with that. You've got the trustee, which is a trust made up of beneficiaries who have already been exposed to asbestos and already are sick with mesothelioma or something like that. You have the future claimants committee, committee representative, which is typically an attorney or something like that works with the trust committee. And these are people that have been exposed to the asbestos but are not yet sick or not sick now. So these committees can get relatively complex. Now, the role of the trustee, if there's a trustee appointed, again, as you said earlier, it typically means that the debtor is not in possession during the bankruptcy process. And my conversation here is assuming the bankruptcy process is a reorganization process as opposed to a litigation process. We'll see the differences in a little while. The Office of the U.S. Trustee is part of the U.S. Department of Justice, which we mentioned. The U.S. Trustee monitors and comments on fee applications filed. Again, they may have the fee auditor and so forth that reports back to them. The trustee is responsible for appointing and monitoring creditors committee, which is what we just saw. That's a real interesting experience because what typically happens is that when the trustee says, okay, let's say unsecured creditors, you're going to have a committee, and then the unsecured creditors want to hire a financial advisor. They'll have a meeting, and they'll invite different firms in to be the financial advisors to that particular committee, say the creditors committee, for example. And those advisors will all be making pitches to the committee, and then the creditor committee ultimately will select a financial advisor from those firms that they talk to. The U.S. trustee must also ensure that all reports and schedules are filed and the fees properly paid in a timely fashion. Now, again, these required reports and schedules are typically done by the debtor if it's a debtor in possession, but if it's a trustee, they may hire a firm other than the debtor's accountants to do these forms. They're not real complex, but if you're not familiar with them, it could take you quite a while. And of course, as we saw with fee auditors, if you take it quite a while, you're not going to get paid for it. And the trustee will also notify the U.S. attorney of any matters that can constitute a crime. So the U.S. trustee has their eyes open for potential criminal activity during the dependence of the bankruptcy. And the U.S. trustee can also appoint another trustee or an examiner or receiver or different kinds of people to handle different parts of the bankruptcy process and bankruptcy activities. Now, generally, who is a court-appointed trustee? Typically, it's an attorney or an accountant. I've worked with one trustee quite frequently. He is both an attorney and a CPA. So that's not unusual. The job of the trustee is to collect and monetize the property of the estate. In other words, their job is to get the best bang for the buck from the assets of the estate, however that happens to come down. When it's clear that the estate is not going to make it through and it's going to need to be liquidated, it's up to the trustee to make sure that it's closed up or liquidated in an expeditious manner for the best advantage of the creditors as opposed to the shareholders. That's where the monetization comes into play. The trustee is accountable for all property received. Trustee ensures that the debtor performs his or her responsibilities related to the surrender or redemption of property. That's an interesting area where investigation gets involved with. Is there property that is actually owned by the corporation or by the debtor that is not being turned over by management? One example of that, which I was involved in a little bit of local litigation, was no big deal, but it was a situation where a company, two brother-sister companies. One company, Company B, we'll say, was a manufacturer's ref for dry cleaning machinery. Company A, which was a brother-sister company, bought the machinery from Company B and set up dry cleaning operations in malls and strip centers, and then sold those dry cleaning operations to people that wanted to be dry cleaners. So consequently, what you had a lot of receivables in Company A from dry cleaning operators who were buying the companies, usually on some kind of an installment plan. And then they had borrowings to pay Company B for the equipment that was put into into the dry cleaning establishments. Well, Company A decided to file for bankruptcy, and Company A filed for bankruptcy, and Company B said, okay, for as part of the closing up the bankrupt estate, we'll buy the assets for $82,000. One of the claims in bankruptcy was from one of the shopping centers that did not get dissolved, did not get thrown out, with about $250,000 during the bankruptcy process for whatever the reasons were, and I'm not sure what they were. That still was a live claim against the bankrupt estate. Again, as I say, I'm not sure what the reason was, but it was still a live claim. An attorney bought that claim for $50,000 from the shopping center and said, okay, I want to buy your rights in that claim for $50,000, which is what he did. He then sued Company B that bought the assets because he said they did not get fair value. Now, the assets were typically, and both Company A and Company B had two different sections in the same building, same warehouse kind of building. And so they paid the $80-some thousand for desks and computers, etc. And those were all tangible value. They had them appraised. Here's what the computers were, or here's what the desks are worth, etc., etc. So the lawsuit was based upon the fact that the attorney that sued indicated that they didn't pay for the intangible assets. Because he discovered later on that they were using the same, Company B was using Company A's telephone number. Company B was using Company A's URL, website. Company B was using Company A's workforce in place, etc. So these were intangible assets that were not paid. So the litigation was filed to basically say, hey, Company B, you bought these intangible assets but didn't pay for them. That's becoming more and more of an issue in bankruptcy. Typically, the bankruptcy courts have said, okay, fine, here's what the tangible assets are worth. That's what you pay for them. Give us the money. We'll split it among their creditors. We're good to go. There are more and more cases now coming into recognizing intangible assets relative to value of assets. So it's something that if you could get involved with bankruptcy, you want to keep in the back of your mind, or in addition to tangible assets, is the purchaser of the property also getting intangible assets. So, you know, that's something, again, is relatively new concept, because unfortunately, most of the time judges are retired attorneys, and attorneys are attorneys, and they're not really sensitive to intangible assets. It takes a financial advisor who is sensitive to intangible assets to bring up the issue. Then finally, the investigate the financial affairs of the debtor, and this is after the property's submitted and returned over. Oppose the discharge of the debtor if that's appropriate, and file a final account of the administration of the estate. Where did the money come from? Where did it go? So that's basically the court-appointed trustee. Now, we mentioned earlier about types of bankruptcy. These are the main types of bankruptcy, and they're related to the chapters in the bankruptcy code. Chapter 7 is a liquidation bankruptcy. It applies to individuals or businesses where they say, we give up, we're not going to do any more. Let's just sell out and pay the bills as best we can. Under Chapter 7 of liquidation bankruptcy, generally the debts are absolved. You know, even if some creditors get stuck, the debts are absolved in the liquidation under Chapter 7 liquidation. Chapter 9 is applicable to municipalities that file for bankruptcy. We had some noise about that. Basically, over the last couple of months, with the suggestion that the states should file for bankruptcy, cities should file for bankruptcy. Chapter 11 is the reorganization section, where if you expect that Yes, you're having some problems with debt, you're having some problems paying your bills, but we think we can work it out. That's a Chapter 11 bankruptcy. That's a reorganization bankruptcy. Chapter 11 of the Bankruptcy Code is saved for family farmers as opposed to corporate farmers. Chapter 13 is a repayment plan, which generally relates to individuals. Call it where the worker says, look, I'm making money. I just need some additional time to pay my bills. They go in under Chapter 13, get the debts reorganized. Maybe the credit card interest is decreased or whatever it happens to be, and they go through with their plan. Might involve paying back taxes, could be any number of things. And Chapter 15 is part of the Bankruptcy Code that deals with foreign matters. So these are the main chapters. It says down the bottom, 1, 3, and 5 apply to all proceedings. 1, 3, and 5 are generally procedural chapters. This is an interesting graph. Pay attention to it. This is the bankruptcy happening filings is from 1995 to 2020. You'll see that shortly after 05, which was, this is actually the low point was the recession beginning in 07 and 08. You see a spike in bankruptcy filings up to in excess of 60,000 a year by 2010. Guess what's going to happen now with the recession and with the COVID-19? We're going to have another spike. So certainly, if you're interested in getting involved in bankruptcy, this might be a time to take our 15-hour, I think it's a 15-hour course in bankruptcy. Because as I understand, reading the press, I have no firsthand knowledge of this, that approximately 20% of the restaurants will be closed. They will not reopen after having shut down. That could be a situation which would go into a bankruptcy. So we might be in the throes of the beginning of an uptick in bankruptcy. And if there's any part of bankruptcy that you might want to get involved with, even if it's simply just filling in the bankruptcy forms for the debtor or something like that, this might be a time to consider that. A little bit of background in bankruptcy. It's to serve a collective action problem among creditors in dealing with an insolvent debtor. Typically, a bankruptcy is filed when a debtor is insolvent, but not necessarily insolvent. Well, we don't talk about it too much on this, but we do talk about it in the bankruptcy course. So let's take a look at that insolvency issue. There's only one court that actually defined insolvency, and basically it said that it's if the fair value of the liabilities is in excess of the fair value of the assets, the company is insolvent. So as you can see, there's a lot of valuation involved there and so forth. It's not book value, it's actually fair value. The company is insolvent if the fair value of the liabilities exceed the fair value of the assets. Over time and in various litigation cases, the second definition has been generally accepted, which is the inability to pay debts on time. So that you can have a company that has positive equity and the fair value of the assets are greater than the fair value of liabilities, but for various circumstances, they're unable to pay their bills when they're due. That also is a definition of insolvency and probably is the largest determinative of insolvency rather than the fair value of liabilities exceeding the fair value of the assets. Obviously, it's a lot easier to determine if a company can pay its bills at the end of the month than it is to determine the fair value of the assets and the fair value of liabilities, and which is higher. So that's pretty much where we are with insolvency. So if a debtor is insolvent, can't pay their bills on time, for example, then they're an ideal candidate for bankruptcy. And the purpose of the bankruptcy is a collective problem solving amongst the creditors to see if they can solve the problems. One thing that's not mentioned in the material, but I think a lot of people understand it, is that the debtor is not the only one that can file a bankruptcy petition. A certain number of creditors can also file a bankruptcy petition on behalf of the debtor. So the purpose of bankruptcy is to provide a fresh start to individual debtors overburdened by debt. This can be a tricky area. We have what we call fresh start accounting in bankruptcy. And after you get all these negotiations and agreements as to the value of assets and agreements as to the value of debts and so forth, to put together a fresh start balance sheet for the debtor. Well, the question is, what happens if you agree that the liabilities are $1 million and the fair market value of the assets are $800,000? What do you do with that $200,000 differential? Well, under fresh start accounting, that $200,000 differential becomes an intangible asset labeled something like goodwill. Some people will say it was goodwill. Other people will say that it's liabilities in excess of assets. But what it does is get your retained earnings account down to zero. So that's the concept behind fresh start accounting. It can be a relatively tricky situation. I had one case a number of years ago. I came in at the tail end of it. What happened was a nursing home in Boston filed for bankruptcy. Their gross, I think, was like $135 million a year in gross revenues. They filed for bankruptcy in Delaware. I live about 15 miles north of Delaware. So the situation was that one of the big eight, or I guess the big four at that particular point in time, CPA firms called Arthur Andersen, which we've all heard of, did a cash flow projection and said, okay, if you get them out and if they retain these liabilities and with the assets of these values, this cash flow indicates that they should be able to successfully leave bankruptcy and be a successful operation. So the judge looks at this, and all the creditors, excuse me, all the different committees look at this, and they say, okay, we'll go with that. Arthur Andersen did it. Looks like there's positive cash flow. Okay, we're good to go. So the judge discharged them from bankruptcy. 6 months later, they're back in bankruptcy. And I got contacted by a trustee saying the judge wants to know, how did this happen? How can Arthur Andersen have performed this cash flow statement showing positive cash flows and they'd be back in bankruptcy in 6 months? What's going on? Well, what went on was fresh start accounting. The value of the liabilities were several $1 million in excess of the fair market value of the assets, so that we had this fresh start plug number, this intangible asset called goodwill, or in other cases, liabilities in excess of assets to balance the books, getting out of bankruptcy. So I'm taking a look at this, and I said, oh my goodness, the cash flow that was done by Arthur Andersen did not support the intangible value that was assigned under fresh start accounting. So I'm really confused. How can you do a cash flow and record an asset, an intangible asset? This was after 141 and 142 came out, and record an intangible asset that isn't supported by the cash flow. It doesn't make any sense. So I contacted Shannon Pratt, whom some of you may have heard of about business valuation and so forth. And I said, okay, Shannon, what's going on here? How can this goodwill be recorded when the cash flow doesn't support the goodwill? He said, good point. He didn't know. So Shannon contacted somebody in New York. He didn't tell me who it was. And here's the answer as far as the accountants are concerned. Fresh start accounting is something specific to bankruptcy. Fresh start accounting is done the way they say to do it. You take the liabilities, and any difference between the liabilities and the assets gets plugged in as an asset. The CPAs, the accountants, don't have an obligation to test the impairment of that goodwill until the next accounting cycle. The next accounting cycle would, of course, have been the next year end. But unfortunately, the company went back into bankruptcy before the next year end, so the accountants had no obligation to evaluate under fresh start accounting whether or not the future cash flow supported the intangible asset. It's an interesting area that you need to be very careful of, where your clients may need to be very careful of. Finally, bankruptcy saves and preserves the going concern value of firms in financial distress by reorganizing rather than liquidating. In other words, we have this concept of going concern value versus liquidation value. And typically going concern value is more than liquidation value. And if the various creditors and committees can work together, then it's probably going to be more beneficial for them to look at going through the bankruptcy and reorganizing rather than trying to liquidate the business. The Bankruptcy Act was established in 1978. Bankruptcy court in each judicial jurisdiction, with jurisdiction to decide almost any bankruptcy-related matter. And this is kind of interesting because the bankruptcy-related matter, any litigation in bankruptcy tends to stay in the jurisdiction. Jurisdiction of the includes both traditional case matters and affirmative actions against third parties. For example, fraudulent transfers, etc. Well, let me talk a little bit about this situation. You can have a disagreement by various parties. A while back, there was a large leasing company that filed for bankruptcy, and they were equipment leasing. So they were getting these monthly payments in from people that rented their photocopiers and fax machines and all kinds of antiquated technology in today's age. So the bankruptcy court appointed or requested proposals from various servicers, various companies that would service these payments, collect the payments, etc. And the court appointed a particular service company. One of the other service companies sued and said, no, they're not, they don't have the capacity to handle this kind of business. So there was actually a trial held to determine which one of the two parties should get the business, even though the court had originally appointed one of the parties. Fraudulent transfer actions are situations where, and we say fraudulent, they could be preferential, it could be any number of transfer actions. But for example, typically if there's a transfer of funds 90 days prior to bankruptcy, and the company did not receive what we call substantially equivalent value, that could be that could be determined to be a fraudulent transfer and get clawed back. So it gets into valuations where if the debtor paid somebody something and didn't get reasonably equivalent value back for what they paid. Bankruptcy judge can hear and decide all cases, the reasonably equivalent cases, the cases of the leasing company, etc. The bankruptcy judge hears and decides all cases and all court proceedings arising a case that district court refers to the bankruptcy court. It's not uncommon to have somebody, a party involved in a bankruptcy, to sue in the district court for some bankruptcy issues. The district court will basically kick that back to the bankruptcy court to hear the argument, as opposed to overriding for or making a determination without the bankruptcy court hearing it. Underlying causes of bankruptcy. Overextension of credit, inefficient management, and insufficient capital. Insufficient capital and overextension of credit kind of go hand in hand. Most of the time, they are the most common causes of bankruptcy. I talked about that fraudulent situation yesterday, where the CFO was doing bill and hold, etc. That was an overextension of credit, was an insufficient capital. They usually go hand in hand. This is where you look at, if you're doing an investigation in bankruptcy, you're looking at the debt equity ratios and so forth. Inefficient management is another not as common reason, but it does occur every once in a while. Inadequate sales, excessive overhead expenses and operating costs relative to those sales. It may be that the sales are adequate, but the overhead and operating costs are excessive based upon the way the company is being managed. Improper product pricing when you're trying to compete. Poor handling of receivables and payables. That's a frequent problem where you see in bankruptcy companies, you see receivables that are a large percentage are over 60 or 90 days. They're not paying their payables because of that. So the payables become unsecured creditors. Excessive interest charges on long-term debt. Inadequate insurance coverage. Poorly managed or excessive cash flow. I have a pre-bankruptcy situation right now, which again started as a valuation issue. This was a company that was a franchise or a franchised, I think they have 89 franchisees that provide specific specialized services to the restaurant industry, both institutional and commercial restaurants. Your restaurants and then your cafeterias and hospitals, cafeterias and companies and so forth. And they got into a loan agreement about 2 years ago, and the interest rate was something like 7 or 8%, which was not too bad. But in order to get the loan, they had to give up approximately $50,000 of equity and other things. But basically, it was an excessive interest charge for what they got. We now are in the midst of a pandemic, and guess what's happening with restaurants? They're closing down. So consequently, the franchisees' businesses are dropping drastically. So they obviously have an issue that their projected cash flow is significantly reduced. They've got excessive interest charges on long-term debts. Compared to the revenue, their overhead is excessive. So I got a call from an attorney in California. Relative to this situation, I suggested they do what we'll see a little bit later is called a pre-bankruptcy, and they didn't want any parts of it. They said, no, we want it's a public company, small penny stock company, and they wanted to have one of the principals of the company wants to take over the debt and buy the assets. So they wanted a valuation done of the assets and so forth. We went through that process. I'm still waiting to hear about what their decision is, but bankruptcy would be an ideal situation for this, because nobody except the principals who want to touch these assets because it's tied into the restaurant industry. So again, these are the different causes. Now, as I said, I initially recommended bankruptcy. They didn't want to do that. They wanted to try this way. The attorneys are dealing with that structurally right now. So I don't know which way that's going to work out. But those were the factors. The overextent, the high interest rates and business problems relative to income, relative to future earnings. What are triggers? What will trigger a bankruptcy filing? Threatened or actual litigation by the creditors, where the creditors are going to say, okay, you don't pay my bill, we're going to sue. Sue for the bill, sue for the unpaid balance. Forced bankruptcy by creditors. We indicated previously that not only debtors can file actions, can file a Chapter 11 bankruptcy, creditors can file for Chapter 11. Dishonesty and fraud. Not an uncommon situation where the books and records look great until they discover that a fraud occurred and the books and records were all wrong. And they wound up basically being insolvent. And this, we saw some of those illustrations yesterday with CFOs and so forth. Collapse of an underlying market. Not, we just talked about that a minute ago, where we have these franchisees that are dependent upon the restaurant market to buy their services, and the underlying restaurant market has collapsed, at least for the short term. And the question is whether or not, how long it's going to take to get back to the level that they had. I think their revenue was something like $400,000 a month, something along those lines. And whether or not it's going to come back and to what extent, particularly since we mentioned earlier, some of the readings are that approximately 20% of the restaurants will never make it back, never reopen. Now, what does bankruptcy proceedings look like? Well, the bankruptcy proceedings, and there's no particular order here, but basically bankruptcy proceedings are entered into in order to administer the bankrupt estate of the debtor in possession. The proceedings are used to determine allowance or disallowance of claims. There may be claims filed when the bankruptcy petition is filed. A creditor or somebody believes that they're owed money can file a claim. Those claims are evaluated as to allowance or disallowance. You hear occasionally like some companies got out of paying taxes, etc. That's all through this allowance or disallowance process. Does the estate have counterclaims? This is where there were what we call clawback, where there was payments made prior to the bankruptcy, and the bankrupt estate did not get reasonable consideration or equitable consideration. There's orders issued when a bankruptcy is filed, particularly in Chapter 11, about obtaining credit. Okay, fine, we're filing, we want to reorganize, but guess what, folks? We need money to reorganize. So the the debtor has to go deeper into debt. So part of the bankruptcy proceedings is what kind of debt will the debtor be allowed to get? We usually call it DIP debt, debtor in possession debt. Sometimes it'll be the current bank that the debtor is using. Sometimes it'll be a new bank. But the debtor needs to get permission during these proceedings to get that debt in order to run the business. There's orders related to the estate's property. Are there excess assets that should be sold off? Those kinds of things. Again, these are orders that are developed in the proceedings. Preferences, we talked about where somebody's paid 90 days prior, and if it's determined that that's a preference, then the court proceeding goes about recovering that preference. As soon as you file for bankruptcy, it's automatic as a point of law that if you file for bankruptcy, all activity relative to creditors trying to sue your estate, they're automatic state. They're automatically prohibited from chasing you, for lack of a better word, to collect their bill. Some people, like taxing authorities and so forth, might file motions to terminate automatic stays. May or may not occur, but they're typically the ones that file these motions to terminate stays. And proceedings to identify and recover fraudulent conveyancing. So these are all part of the bankruptcy process. Other areas are assess the ability to discharge debts. This gets into, is a reorganization realistic? If we reorganize, will we be able to discharge debts? If we give up 10% of our money that we are owed, will you be able to discharge debts? These are all negotiated situations. There can be an agreement to, a court can say, well, okay, fine, we will discharge you from debt under these this fresh start accounting. There can be objections to that. It's not uncommon to have 3 or 4 or 5 objections to a particular plan of reorganization, which we'll talk about briefly in a few minutes. It's also identification of the validity and extent of priority liens. That gets back to whether or not you've got a real claim. Confirmation of the reorganization plans is the big one. As you mentioned earlier, the debtor will usually write a plan of reorganization. If they don't do it timely with extensions, then the creditors can write a plan of reorganization and bring that plan up for confirmation. The reorganization plans need to be confirmed by the parties and by the courts, so that that in order to get the company going back in the world again, and get it out of bankruptcy, there needs to be this confirmation of the reorganization plan of reorganization. Things like if they need to enter into leased property or need to get leased property in order to operate, that needs to be approved in the get an order in the court proceedings. Unless a future creditor, for lack of a better word, gets an order, they're at risk of not getting paid. So we do need these orders for people to say, okay, fine, I'll loan you money. They get priorities in repayment and so forth. Same thing with leases of property. Court proceedings, we kind of alluded to this earlier, sales of the estate's property, and any other proceeding that affects the estate's liquidation or the adjustment of debtor-creditor relations. All of these are typical proceedings that happen in bankruptcies. They may not happen in all bankruptcies, but they do happen. This is a listing of the forms we've mentioned several times. These are the forms that are required for filing bankruptcy proceedings. We start with a voluntary position and then proceed through all this list of forms that are filed. The bankruptcy petition has schedules attached. These schedules are just as they're listed: real property, personal property, et cetera, et cetera. Who are the creditors? Who are the creditors holding secured claims? Who are the creditors holding unsecured claims? Who are the creditors holding non-priority claims, et cetera? So these are all the forms that we referred to that many times the debtor will hire an accounting firm that has experience in the area to prepare these forms. Okay, Chapter 7 we talked about earlier is a liquidation chapter. Generally, we with business valuation and investigation and all that kind of stuff, we generally will not be in Chapter 11 as Chapter 7 cases, but you need to be aware of them. They involve liquidation of an individual or a business. You may be involved in a Chapter 7 case if you're going to be filing final tax returns, those kinds of things. Chapter 7 provides for the appointment of a trustee. Since you're going to be liquidating, there's no debtor in possession. There's a bankrupt estate, there's the assets, and a trustee will be appointed to liquidate the assets and distribute the liquidation proceeds to the estate. The fresh start accounting proceeding in Chapter 11 basically means the individual or business that's filing doesn't necessarily go out of business, but they do get a fresh start. They're back at ground zero. They will if it's a business, they will typically have given up all the equity that they might have, and that sort of thing. Typically, the equity obviously is reflected in the assets that were sold. So the business ABC company might still exist, and the fresh start accounting is going to look like 0 assets and 0 liabilities, presumably. Chapter 13, again, we won't usually get involved with Chapter 13 cases. This is the wage earner plan. You might get involved in Chapter 13 if you're engaged by the attorney who's handling the Chapter 13, and they need some assistance in developing a wage earner plan, looking at the facts and circumstances to see what can be approved by a court. But a Chapter 13 plan enables the individuals with regular income to develop a plan to repay all or part of their debts. And the idea behind the Chapter 13 plan is to reduce the economic losses associated with liquidation. If you do have a liquidation, the creditors only want to get what they get. With the Chapter 13 plan, where there is a continuing cash flow of wages, the creditors do have a possibility with a well-designed plan of getting their money back at some reasonable rates of interest. For example, I had one case where it was a Chapter 13 case where the situation was such, look, I'm earning money, and they had one piece of leased equipment that had a real estate, and this was a while back, 13% interest rate attached to it. The creditor backed down to a 7% interest rate. Same thing with credit cards. If you don't make your credit card payments for a couple of months, you might be up at 24 or 30% interest rate. At Chapter 13 might allow you to get that back down into a lesser interest rate. So that's how you use Chapter 13. But again, if you're involved with the Chapter 13, it might be as a consultant to the lawyer. Chapter 11 is what we're primarily involved with, where the filing gives the debtor protection, time to reorganize, and protection of the court. It allows the debtor or trustee to continue operating the business. It reduces the economic losses associated with liquidation. But it's not unheard of that a Chapter 11 case, when all the investigation is done, all the analysis is done, a Chapter 7 case might revert to a Chapter 7 liquidation case. It does happen, where everybody with good intentions goes into a Chapter 11 to hopefully reorganize the debtor, but they have issues and it's not going to work, so they go to a Chapter 7 and liquidate the assets. Parties can file either a voluntary or involuntary plan. We mentioned that a couple times before. It can be done by the debtor, or it can be done by creditors. This is Chapter 11. This is an important bullet point. It says generally a lack of pre-bankruptcy planning. Now, what that means is that typically you've got to file a Chapter 11 if you have not done bankruptcy planning, pre-bankruptcy planning. We call them pre-packs. What a pre-pack is basically is that, okay, the company's having problems. We owe these creditors money. Let's have some negotiation with the creditors outside of bankruptcy. You have negotiations with creditors outside of bankruptcy. Everybody agrees to what will happen. So they do this plan that's pre-packaged, if you will, and submit that as part of the Chapter 11 bankruptcy filing. It's becoming more and more common these days. It really didn't get common until the mid-2000s, 2004, 2005. They did have them, but it wasn't common. Today it's getting more and more common, where you'll bring someone, we'll talk in a few minutes about turnaround management, where you bring in a turnaround management expert, and one of the things they might suggest is a pre-pack Chapter 11 bankruptcy. But generally, where you have these Chapter 11 cases where there's not been any planning, it can get very, very messy. Sufficient pre-petition planning can help secure a better rate of reorganization success, where you recognize, if you're getting, if the debtor is resisting recognizing their situation and doesn't file a Chapter 11, and the creditors come in and do it, the debtor is basically is going to have a problem with success as far as getting out of it. What are some pre-bankruptcy planning issues that come up? Cash management, cash accumulation, management operations, and that's not unusual in a pre-pack that there'll be some change in management or change in operations because the people that were operating the business got them into this trouble in the first place. There's some PR issues that need to be done, legal requirements, any pre-pack that might be done needs to, and agreed to, needs to be in writing. And of course, financial reporting and taxes need to be taken care of. Now, the automatic stay we mentioned before is automatic under the law. Creditors can't pursue the debtor if there is a Chapter 11. Creditors receive notice of the filing of the petition. The stay arises by operation of law and requires no other judicial action. This is why in the papers, newspapers, you'll see frequently advertisements are run, so-and-so is filed for bankruptcy. This is the reason that they do that. So they can come back and say, okay, fine, they received notice. It was advertised in the local newspaper. If they don't read the local newspaper, which is becoming more and more uncommon today, they might be out of luck because you need proof of advertising and so forth. As long as the stay is in effect, creditors cannot initiate or continue any actions. We mentioned before that there could be a motion to lift a stay for a particular creditor, typically a taxing authority. Under specific circumstances, a secured creditor can obtain an order from the court granting relief from the automatic stay, which is what we're just talking about. Now, the main document, the Plan of Reorganization, or POR as we call it. Chapter 11 requires a debtor to file a Plan of Reorganization. The Plan of Reorganization details how the debtor will pay the creditor's claims. It details how the business will be restructured from an operational and financial standpoint. It details what the company will look like when it emerges from the bankruptcy. As an example, some debt holders might say, okay, fine, we'll cancel our debt, but we want X% shares of the company. Those kinds of negotiations will occur. So what does it look like? What does the company look like? What does the company's balance sheet look like when it emerges from bankruptcy? And the plan should reestablish the ability to be financially self-sustaining. In other words, if the Plan of Reorganization looks like it's going to go down the tubes in 6 months, it's not going to be approved. It represents a blueprint for satisfying creditors and equity security holders. In some bankruptcies, the equity security holders may never be satisfied. They might just be out of luck and get something, as we said in the earlier illustration, they might get warrants if they want to buy in the future. They can buy in. But a lot of times their holdings might be diminished. As an illustration, if a creditor says, okay, fine, I will get rid of my debt if I get a 20% interest in the equity of the company. What are the security holders going to do? They'll probably litigate and all that, but it would probably fly in the Plan of Reorganization. As it says in the final bullet point, not all creditors and equity holders will be satisfied, as there are insufficient assets and earning power, hence the Chapter 11 petition. But presumably, if it was a successful Plan of Reorganization, they will have future earnings and profits. The plan provides a description of the consideration that each class of creditors and equity holders will receive. As we said, may be recapitalized by the creditors, giving up some of their debt in exchange for equity. There are generally several negotiations and revisions that factor into the development of a plan. There can be tons of renegotiations in plans of reorganizations. There can be competing plans of reorganizations. I've had bankruptcies where there's been at least a half a dozen different plans of reorganizations presented by different constituencies, including the debtor. But the bottom line of the plan is that it must meet the business objectives and satisfy the requirements of the bankruptcy code. And the reorganization of an entity involves many parties who may need the assistance of financial advisors. That's where we come in. We're the financial advisors during the plan of the reorganization process. I mean, it happens frequently where if you're representing a committee and another committee or the debtor comes out with a plan of reorganization, you have to do the analysis of the plan of reorganization. Can your client, the committee, live with the plan of reorganization, et cetera? So you're pretty involved in analyzing the plan of reorganization. And of course, the financial advisors for the debtor is involved making significant input into the plan of reorganization. The POR must provide for administrative expenses, employee wages and benefits, taxes, debtor in possession financing, DIP financing, as we said before. DIP financing gets a preference. DIP financing will get a preference before the creditors. Administrative expenses. If you are properly approved by the court and file the appropriate papers to be the financial advisor to a committee, you become an administrative expense and you get a prime lien, if you will, on the assets of the company. So I said that large bankruptcy where I work, where the company was paying $70 million a year to the financial advisors. Those are all administrative expenses. They took precedence over all the other creditors. So you need to get your paperwork done in order to get paid. The plan cannot discriminate unfairly and must be fair and equitable toward each impaired class that has not accepted the plan. The impaired class are people who are not secured creditors. They may not have any, they may be unsecured creditors is typically the impaired class. The court will not confirm the plan unless it can determine that each creditor or stockholder will receive an amount not less than the amount that they would have received under Chapter 7. So this is one of the exercises, if you do business valuation work, one of the exercises in Chapter 11 is showing that if they did a Chapter 7, they would get less money because the assets have lower value. Again, remember, we're talking about valuation here. Chapter 7, we're talking about liquidation standard of value. And in plan of reorganization, we should be talking about a going concern standard of value. So those are valuation exercises that might be done by the financial advisor. Excuse me. Now, let's get into the next area of the turnaround management. These are the people that you would call if you are in trouble, but you had not yet filed for bankruptcy. There's an association called Turnaround Management Association, TMA, which if you're interested in this work, bankruptcy work, you might want to consider joining. The two keys for a business turnaround are to solve the operational problems and restructure the debt and equity of the business. Obviously, first, you need to, as it says here, number one, evaluate the management. Is management an operational problem that needs to be solved? You need to make that determination. Stage number two, the situation analysis. The operations, how do they handle, or maybe better, are the customers stable? Is the industry stable? What's going on? These are all operational problems. Design and selection of a turnaround strategy. How can we turn this business around? How can the debt be restructured? And these turnaround, the TMA professionals actually negotiate with your creditors and so forth. Is there any emergency action that needs to take place? Emergency financing, for example. Finally, the business restructuring. under the guidance of the turnaround management professional, and finally return to normal. Now, if a turnaround management professional is engaged and they go through this due diligence analysis of analyzing the operations, analyzing management, etc., it could be that they will have to file a Chapter 11 anyway, or even a Chapter 7 in the worst case. But turnaround management is a service that's provided by a lot of CPA, a lot of the bigger CPA firms. One that I was involved with up to 2013 had a pretty substantial turnaround management and bankruptcy group. I was in the litigation group of that firm, as opposed to, I went in and assisted every once in a while with the bankruptcy group, typically in the valuation area. Turnaround management can facilitate out-of-court settlements. In other words, settlements with creditors without going through the bankruptcy process or without going through the litigation process. Typically, what the turnaround management person will do is request meetings with a few of the largest creditors and a few of the small creditors to effect an informal agreement. You know, what can we agree to here in lieu of litigation or in lieu of filing for bankruptcy? Seek informal settlements of an extension and or time, or pro rata settlement is a common technique that's used. How about instead of having to pay you in 5 years, we can pay you over 7 years? How about instead of you charging us the 7% interest, we pay 3% interest? You know, those kinds of negotiations are handled by the TMA professional. Assignment for the benefit of the creditors. So, debtor will voluntarily transfer title to its assets to an assignee, who then liquidates them and distributes proceeds to the creditors. Generally requires a consent of all creditors, because it depends upon what assets are being liquidated. You can't obviously liquidate assets that you need to continue the business. But some of the creditors may have liens on assets that you can liquidate. And so that you will need consent of the creditors to liquidate those assets, since in many cases you might be taking away their collateral. Part of the turnaround process is due diligence. And we have this Investopedia definition, which I hate in professional circles, but Investopedia is easy for lay people to understand. And you define due diligence as an investigation or audit. It's not an audit, I'm sorry. It's an investigation of a potential investment or product to confirm all facts that might include the review of financial records. Due diligence refers to the research done before entering into an agreement or a financial transaction with another party. This is what's done in the turnaround process, is a due diligence of investigating the facts or circumstances, confirming the facts and circumstances that might include a review of financial records. I say an audit because the word audit is poorly used by lay people. They think if you're talking to an accountant, you're talking about doing an audit. That's just not the case. It's misinterpreted. It gets accountants in trouble when they use that word. And due diligence, at least for many of us, is an everyday act. I know in my practice, I do due diligence almost unconsciously these days. So what's the process? What do you have to do in order to be diligent? You want to define the project goals and objectives and analyze them. You want to do a preliminary inspection or preliminary overview. Then you want to fully, you want to get a general sense of what's going on. You want to fully vet and document persons and systems. You want to assess the business case and plans. Incorporated within that are the industry analysis and so forth, the economic analysis. You want to do the risk analysis based upon the industry, based on the economy, that where you're assessing the risk. How much is the risk? How do we quantify that risk? How do we handle that risk? Then we have a final offering or gateway for ongoing due diligence, and we go back to analyzing the process. So it's a continual continual circuit until we get to the point where we've resolved the issues of the debtor or of the client. And as I say, during this due diligence process, it may come to a point where what is effective is filing a Chapter 11. What do you need to look at during, the author here calls us types of due diligence. It's really what areas do you need to look at when you're involved in due diligence. You need to do operational due diligence. I tell people when I'm looking at operations, I do flow charts. They say, what's a flow chart? I've been doing flow charts for years, and they're the most helpful tool to look at a picture and see an entire scheme. Whereas if you do operational due diligence, you write a narrative, it takes people a while to absorb and to get it through their head exactly what's going on. So I use use flow charts. Financial due diligence, looking at the quality of the assets, the quality of the debt, and so forth. Legal due diligence. Particularly in smaller companies, legal due diligence becomes an issue because they may have some stuff on their books as assets. They're not titled in the company's name. They're maybe titled to an individual's name who's a shareholder. Legal title is important to consider in these particular situations. Human resources due diligence. Are the people that are working there productive? Are they specifically trained? Do they know what they're doing? Or is it a situation where you've got family members who are being paid and are not doing the work that they're getting paid for, or not doing it at the salary, not doing the work at a salary level that they're getting paid? IT is a big one. IT due diligence involves the systems, the protection, the security of data, the security of the entire system. Intellectual property due diligence does what's the nature of the intellectual property? Is the intellectual property trademarks, service marks, copyrights? Exactly what is it? Does the company have and this gets back to the legal due diligence, does the company have appropriate title to intellectual property? If the company bought intellectual property, was that transaction effectively paid for? Did they follow the agreement to have transfer? I've had one a number of years ago where an individual developed a patent but didn't have the funds to develop the patent. So a company said, okay, fine, we'll start a company 50-50. We'll put in the capital, you put in the intangible assets, and we'll develop it together. Well, after spending $500,000, the investment company said, we don't really understand what's going on here. Give us $1,000, we'll give you back the intellectual property. They signed an agreement that the company would give back the individual the intellectual property if the individual paid $1,000. Guess what? The individual never paid $1,000, but he took back the intellectual property. That's, it's probably not an issue now, but, a number of years ago, it could have been an issue. So intellectual property is important. Due diligence, tax due diligence is important to make sure that things are structured effectively from a tax standpoint. What about NOLs? Who owns the NOLs? If we do certain transactions, the NOLs might go away. If we do other transactions, the NOLs might be preserved. So this is all in the area of tax due diligence. Due diligence example, 9-month process, and they're saying it's 9 months pre-letter of intent to close. Asset sale versus stock sale. In this particular example, they're talking about selling off some assets or selling stock. The teams, who's the buy side team, who's the seller side team. The costs. The costs basically are you're looking at the quality of earnings. Are these real quality earnings or not? I'm not sure why the author came up with 115K. I guess in his illustration, he was using an example of $115,000. Inventory valuation issues, always a problem. And post-close situations. If there's a sale involved, what are the post-closing issues that might come up? Again, if there's an asset sale and working capital is being acquired, there may be some adjustments to working capital needed post-closing. So all of these situations, all these examples are situations where due diligence is required. The author gives some examples of lack of due diligence examples. Some of these might be strung out not because of lack of due diligence, but because the transaction was not being handled properly by a turnaround person. The spa matter, using an example where it was in litigation for 2.5 years. Restaurant partnerships, ongoing for 2 years, litigation ongoing. Wine distributor settled after 1.5 years of litigation. I just finished a case that was settled. It's been going on since mid-19 with a Belgian beer distributor and a Belgian beer brewery and a United States distributor. And that started, I think, in 2018, if I'm not mistaken. Curated advertising issue still going on after 2.5 years. Fitness technology settled after 2 years in litigation. So if you're advising clients, due diligence on the front end is critical. Like this fellow I was telling you about that I'm doing some consulting work for, it's real clear he has no interest in doing due diligence. He wants to do what he wants to do, and he wants somebody to tell him how to do what he wants to do, even though it may not be the best thing for the organization. But the due diligence, I did my due diligence, and it's up to him if he wants to accept it or reject it. This is a due diligence documentation, or as I call it, a due diligence checklist that you can use. And it's just basically simple things that you need to consider under various facts and circumstances. I'm not sure what the source of the document is, but there's a book mentioned in the back that might have this in there. But it's basically a checklist. Most people in turnaround management have some kind of a checklist that they rely on in order to go through the due diligence process. Documentation, live tracking of documents. As with any kind of litigation, document requests and receipt of document requests are critical. So you need to track the documents. In complex cases, I use a document map. A document map I pulled from a book that I mentioned yesterday, which was Darrell Durrell's book, The Financial Forensics. He has an illustration in there of a document map, and which is what I use when I have complex situations in litigation. And in litigation, I'm sure if any of you have experienced litigation, you've all experienced where you've asked for 10 documents and got 5. And this is an aside. What I do when I'm doing my engagement letters, whether it's for litigation, and typically it's for litigation, whether it's for marital disputes, whether it's for commercial litigation or whatever, I will write up a document request list. And after I ask for a specific document, underneath that I put in what's the purpose of my asking for that specific document. For example, 5 years of financial statements. The purpose is to determine a history of the company. and measure that against whatever you're measuring, lost profits, business valuation, whatever it happens to be. The reason the attorneys like that is that, now I send that to the attorney, engaging attorney. It's up to the engaging attorney whether or not he wants to put that, he or she wants to put that process under the specific document that's being requested. That's their call. But what happens is if we are forced into what we call a motion to compel production of documents, if the other side doesn't give us all the documents that are requested, it gives the attorney something to argue about. Well, here's the reason, Your Honor, that we needed this document. And he reads the purpose. And some attorneys jokingly said, gee, all I need to do is to do a motion to compel production and attach your document request that you gave me that I didn't give to the other side. So the tracking of documents is extremely critical in a lot of these areas. If you have file access, if you need to have some kind of a log as to who has had file access. In criminal cases particularly, if anything ever develops into criminal cases, that becomes a critical issue as to who had access and when did they access the documents or the files. Status of review, that's always a continual process. You're always reviewing what you're doing and what you need to do. Assignment of accountability, this goes, what does the attorney need to do? What does your staff need to do? What do you need to do, etc. Prioritization of record reviews. If I'm asking for the record, it's a priority. So in some cases, yes, once you get a record, you can say, okay, fine, the rest of them are not as important as I thought they were originally. So you do need to continue evaluating the records that you're reviewing and their importance in your particular case. Identification of the issues. In any kind of analysis or any kind of due diligence, the issues are going to continue to change. They're going to continue to change based upon what you're finding out versus what you originally thought. So the identification of the issues continually changes, and you need to determine what impact that's going to have on your investigation. Monitoring the activities of the debtor. In order to monitor the activities of debtor, you need to understand the debtor. You need to understand the debtor's business model. For example, I deal frequently with franchisors as clients, typically as defendants, because when they're being sued by the franchisees. But before I can spend much time in dealing with a debtor that might be a franchisor, and there are occasionally debtors that are franchisors, I have to understand what their business model was. How did they make a buck? How did they operate, and so forth, which is the business activities. What the business model is, what do they accomplish, what do they attempt to accomplish, what do they accomplish, and the business activities, how do they go about accomplishing what they want to accomplish. Competency of management is important. It's not infrequent that somebody is running a business purely because they wanted to, and they're really not competent, sufficiently competent, let's put it that way, not sufficiently competent to run that kind of a business. And you need to evaluate that. Is there internal governance and oversight issues, or is the company being operated by one or two individuals? Again, not an unusual situation for smaller companies, but even with larger companies, internal governance becomes ingrained. And there's what started out 10 years ago as a group to oversee the activities of the company, now as an ingrained brotherhood, if you will. How many times do you hear of board of directors, approving things that should not be approved, or that are causing problems. But there's a powerful board member, and the board yields to the pressure. All of the situations, there's usually multiple situations that are defined. What are the steps being taken to remedy those situations? And again, if you're looking at a debtor situation, what factors cause the insolvency? Again, that would be all the way back at day one when you're first doing the turnaround work. If you're called in because the company's insolvent or can't pay their bills in time, more frequently, what's causing that particular issue. Red flags. When you're monitoring the debtor's activities in a turnaround situation. Increased sales at expense of the company's sustainability. This is one of the first things that happens when you have a company that we're running into insolvency. They think if I increase my sales, everything will be okay. Well, how do I increase my sales? Why decrease my selling price? Or I sell to less than appropriate customers with poor credit standards and so forth. This is almost always the first step in a problem situation with a debtor. Many companies, and I'd say most companies, think that they're having problems, that if they increase sales, no matter how they increase sales, that's going to solve their problems. In 99 cases out of 100, it actually makes their problems worse. And the reason it does is because they're lowering their prices, so consequently they're not making as much, and or they're extending credit to people who should not have credit extended to them. Owners or managers using company funds to sustain a lifestyle. This you can see easily by looking at ratios of owners and officers' compensation against industry benchmarks, that the owners and managers are not giving up their lifestyle no matter how bad the company's doing. They're continuing with their Maseratis or Lamborghinis or what have you, even though the only thing the company can afford is a Chevy, where they're more concerned about lifestyle. I think I mentioned yesterday about one township manager that stole approximately $4 million purely to maintain a lifestyle. You see that with owners and managers in company, particularly where the situation where the owners are enjoying the benefits of sucking the money out of the company. Other situations, it's not so obvious, where managers are using company funds where the owners aren't paying attention. The owners aren't doing it, the managers are doing it, but owners aren't paying attention. This goes back to the situation I mentioned yesterday with the contractor, where the owners weren't opening the bank statements, even though they were told to do so. Size and volume of related party transactions. You need to take a look at related party transactions because many times they lack economic substance. Situation, for example, I had a divorce case one time, which was a Subaru dealership up in New England states that the husband owned, and oh my God, the business is doing terrible. The business isn't worth anything, et cetera, et cetera. And when I looked into it from a valuation standpoint, I found out that he was paying a fortune in advertising, way more than other dealers in the area were doing. I looked into it, found out he owned the advertising company. So he was just sucking money out of the company, calling it advertising. Other situations where, and we see this frequently in small companies, particularly where they're trying to manage taxable income, we see accounts receivable where there's no intent to repay. Matter of fact, there's no intent and there's no documents. It's just the accountant made an entry, debit accounts receivable, owner, credit, cash. And I monitor several, I've got a real strong tax background. I monitor several tax listservs. And I am amazed at the number of questions that come up relative to the officer's receivable, and there's no documentation for it. There's no interest payments. Well, I impute interest. Well, that's fine. If you don't have any documents that it's a receivable, your journal entries, don't make it so. So these are different areas where transactions and are different areas of red flags in this area. Do we have any? Oops, excuse me. Sorry, I messed it up. I'm sorry.
You're fine. Was that your last slide or?
The last slide is that people see it, have references, which is the book by Newton, which is an 09 edition. It has a lot of this information in it, and I'm sure they have the PowerPoint, so it's the last page. And I believe I may or may not, I may be mistaken that the book is being rewritten. I'm not sure, since it was written 11 years ago. But there hasn't been that much change in the bankruptcy process or the bankruptcy system or the definition of insolvency and so forth to cause a problem. So it's still probably a safe book to use. The one slide that I messed up was the slide relative to whether or not there are any questions. So I will leave that to you, Wendy. Do you see any questions in the chat box?
I see nothing.
And I
think we just, I think you guys just did such a great job that.
I think we're on time too.
Yeah, it's a good thing.
Thank
you, Dermot. We really appreciate being here for the last couple of days. It's been very informative.
I'd like to thank the participants. I'm sorry for the technology screw-ups that we had.
It happens.
Well, believe it or not, my first webinar was in 2008. In 2008, so you can imagine the changes in technology over the years that I've come to deal with. So it gets a little bit confusing. But anyway, thank you for your attention. Thank you for participating. Some of these days we talked about have individual courses that are a week long and about 15 hours, like bankruptcy. It has a course that's about 15 hours. I think it's 5 days, 3 hours a day, if you want to get more into these details. Because of the economic situations today, I would encourage you to think about bankruptcy or think about maybe somehow trying to take advantage of what's going to happen with this COVID-19 situation in the businesses. So with that, I will say thank you. Thank you, Wendy.
Thanks, Dermot.
Okay.
Everyone, thank you so much for being here with us this week. We really appreciate it. We hope that you're going to be joining us for some of our conference next week. It's going to be pretty great. We've got our fingers crossed about technology, so we'll see how it goes. Everyone have a wonderful weekend. Be safe, and we'll see you next time. Thank you. Bye-bye.